So like adding that to industry recognition is going to be huge. So I'm very excited, very excited. Hopefully. I love this woman's environment. You know, we have another, I think I told you another first-time director we supported. Yeah, correct. That's a woman named Scarlett Johansson. Yeah, she was so cool, calm, collective, and nice, which is what you want, and just professional, right? You want someone who's professional, who like, I don't know, it's so interesting because you work with so many people and almost everybody's nice. And then there's Blake, who she's totally different than everyone else's story. I'm sorry. It's like you're not to say anything bad about her, but she's just. Hey besties, welcome back to my channel. It's Katie Joy. So I figured something was going to drop because I'm assuming that behind the scenes inside the Reynolds and Lively house, things are anything but calm because after the unsealed audio became public between Clear Yup and Steve Sawich, Ryan and Blake probably started raging because what we heard in the call was not exactly how they portrayed it. The audio was supposed to make Blake look like the victim of a toxic work environment. It was supposed to support her that there were these other people coming forward with complaints. Spell Downey and his abuse, and it was supposed to be proof that she had been wronged by Wayfair and Baldoni, but instead it undercut her story. The tape and the recording actually reveals that the fight wasn't about harassment or discrimination at all. It was about power and creative control and how she wanted to shape a public perception of the movie through the marketing and the backlash that was following once the release of the movie came because of the distance between Lively and Baldoni on the press tour, the way that she was behaving on the press tour, and references by Shurowitz to Ayub about how a couple of weeks so far they had really thought they might have to go into court, but they decided not to. And that all fell in line with Blake and Ryan demanding they put out this letter taking responsibility for the backlash. And it's also around the same time that Jones works hands over data from Jenny Abel's phone that wasn't hers to have. So how does Blake respond after she gets negative headlines right about this evidence that really pokes holes at her credibility? Well, her team files a motion for sanctions, and they accuse Wayfair, Wallace, and all of the different parties of spoliation. And so she says now they're missing evidence. They've deleted it. She says that while Wayfair, Baldoni, Jamie Heath, and the PR partners did, Wallace and Tag used Signal voice memos and auto-deleting messages to coordinate a secret digital campaign against her in late. She claims that they used Signal to plan talking points about how to bury her. Impress shared voice memos mocking her and strategic strategizing how to frame her as difficult, and communicated about those plans right as the controversy around It Ends With Us went public. It's amazing that she knows that things happen that she has no proof of, and according to her, those messages and voice notes would show retaliation, and that they weren't just reacting to her, but actively trying to destroy her career. And she said that those chats disappeared because they had auto-delete enabled, and they failed to suspend that once litigation was foreseeable. But she has no proof that those specific messages ever existed. She has no screenshots. She has no metadata, no backup logs, nothing. Her only evidence is circumstantial. She knows that they use Signal and that some messages exist after December and before, but nothing from the months she said the campaign began. So she's asking the court to assume the worst, that those deleted Signal threads contained incriminating material and punish them accordingly. So she got some stuff from Skyline from Signal after December but she doesn't have anything from before, right? And so she's assuming that these are existing. She assumes that it was all negative against her, and it was all retaliating for sexual harassment. So she's asking the court to decide on evidence that doesn't exist. And now she is asking them for sanctions under spoliation under rule of the federal rules of civil procedure. So she's not just asking the judge to give them a slap on the wrist. She's asking for some of the harshest penalties available. So here's what she wants. She wants an adverse inference instruction. So she wants Judge Lyman to tell the jury that they can presume that the missing signal and voice messages would have proven her case, and that these chats showed a coordinated PR plot against her. And that's powerful, because jurors are allowed to fill in blanks in her favor. So she's asking for basically the judge to tell the jury that all of this deleted evidence that she doesn't have was deleted because it proved her case. She also wants an issue of preclusion, so she's asking the court to bar the defendants from denying that they executed the digital campaign. In other words, she wants the judge to declare the fact as true because she says the evidence proving it was destroyed. Again, evidence that she only circumstantially believes exists. She's even trying to use the missing evidence to establish New York jurisdiction over Wallace PR, arguing that their concealment should count as proof that they acted inside the state. And that's such a long shot. She's also demanding that they pay her legal fees for filing the motion. So, this is so severe. And if you recall, she's already filed sanctions to basically have Friedman disbarred. So he doesn't. There's no trial attorney. She's filed to rule her as the presumptive winner in the Wayfair case. And now she's asking them to just not let them mention that the digital campaign didn't exist. And that tells the jury that it did exist, and they deleted all the evidence to help me win. This is weeks after Ezra told the court that they couldn't respond to the motion on the judgments of pleadings because they didn't have the time, and they had time to file this motion for sanctions. And this is also after she told the court that they had thousands of pages, evidence that could amend her complaint and prove her case. So this judgment on pleadings is really ridiculous because she'll just amend her case with all of the thousands of pages of evidence. But now this week, she's telling the judge she doesn't have the evidence. So which is it? It's messy. So how does she get these sanctions? She has to prove that the evidence existed, that they had a duty to preserve it, that it was lost because of their failure to take reasonable steps, that it can't be replaced, and they acted with intent to deprive her of the information. And that's the last one, is that the intent to deprive her of that information, and that this isn't going to work because Lyman already ruled that using auto-delete alone doesn't prove bad faith. You have to prove deliberate destruction after being told to preserve, and she never sent them a preservation notice. She relies on the fact that she sent them a letter in November on the protections that return to work, right? That was about sexual harassment, not about retaliation. And that letter didn't include a legal threat. It just said she reserves all rights. So on August of, Judge Lyman addressed the issue with the signal chats and the auto-delete feature, which she now wants them to say is sanctionable offense. She had asked him to compel the Wallace defendants to produce signal records or explain what happened to them, and the court told her no. He wrote that a party can't be compelled to produce documents that don't exist, and that Blake hadn't shown any proof. They did. He accepted that Signal's auto-deletion feature was on, and there was number evidence of intentional spoliation. That was the end of it. So her new motion is just repackaged of that same argument. But this time she filed right after her credibility imploded with the audio. Release it. It's like every single time something in her case collapses, she does something for sanctions. Right when it came to the Van Zanten lawsuit, when it got exposed, she started threatening Brian Friedman. She issued subpoenas to his law firm. They made wild accusations against them. They issued safe harbor letters. They accused them of using end-arounds. Every time something happens that's favorable to Wayfair, a motion for sanctions happens. So now we're seeing that an audio contradicted the harassment claims. They knew the audio was going to be unsealed. They knew they needed to counter something, right? They knew they needed something to be put into the docket. Now, after not filing anything in the docket for days, public opinion's flipping again on her. And now even the entertainment press is starting to question her motives. You've got more and more negative stories about lively even in the mainstream media. So the filing is trying to pivot her back into the victim to say, I can't prove it because they destroyed the evidence, and that plays well for PR, but it doesn't hold up in the courtroom because she has to have evidence that they intentionally destroyed. Evidence, and I just don't know that Lyman is going to grant sanctions for evidence that she's never proven to exist, especially when the duty to preserve wasn't triggered until much later. And she cites all of these documents, which are all sealed and all redacted. So again, the public is only getting half the story here. He might allow limited questioning or note the signal data wasn't reserved, but sweeping and jury instructions that she's asking for. I just don't see that happening. I actually find it super wild because the court already told her that there was literally no proof that they intentionally deleted anything or that any evidence of these conversations occurred on Signal or that she had proof that they existed. The only reason she claims that they must exist is her assumption that they said they used iMessage, Signal, email to discuss things, right? Things can also be discussed over the phone, which there would only be a record that the call existed, right? But that's still not proof. She spends a lot of time using their depositions to try to prove that these documents actually existed and they had a duty not to have on the auto delete, and she runs and uses the quotes untraceable, no fingerprints all over the place in the hopes to convince the judge that all of this was being done willfully. So this is what she says, that their obstructive conduct in this litigation confirms that sanctions are appropriate. The facts discussed immediately above were only recently obtained by Miss Lively, after overcoming substantial discovery hurdles created by defendants. There is no dispute that each of the defendants used Signal as an inferior mural messaging platform to discuss issues related to this litigation. This court has already acknowledged as much. Miss Lively first requested these communications on February and the parties thereafter explicitly agreed in the ESI protocol governing this to manually review the communications among any party to the action. Yet for almost months they've refused to produce any of them and forced this Lively to file repeated motions to compel. And every time she requested these documents, they kept telling her that they cannot produce what they do not have or what doesn't exist. And she writes in response, Wallace defendants admitted that because they did not disable the Signal's auto-delete feature, no responsive communications remain in their possession, custody, or control. And the court accepted this, denying Miss Lively's motion. On this score, the court ordered the Wayfair parties to produce Signal communications no later than September and instead of complying, they made in our request for a 1-week extension to complete this production, which this court denied. And ignoring the court orders, they engaged in self-help and produced just a handful of Signal communications late, and then unilaterally continue to produce more and random intervals with no explanation for another month until October Critically, however, none of these communications predate December The Wayfair defendants have established a clear pattern of failing to comply with their discovery obligations. They have not produced a compliant privilege log for all withheld Signal communications. Essentially what she's asking the judge to do is to sanction them because they used a platform that didn't auto-save messages, they spoke on the phone, or they used voice memos that didn't save, and that this was all done intentionally because they wanted to have an untraceable smear campaign to destroy Blake Lively. And indirectly, what she's actually telling the court is that I can't prove my case. I don't have thousands of pages of evidence. I can't amend my complaint to prove that this happened. And the reason why I can't prove that this happened is because I don't have the evidence. And you need to say that they hated and destroyed the evidence because it doesn't exist. The irony is that there was like a motion to compel, and it was relating to the messages after December And in a letter to the judge, I'm pretty sure Michael Gottlieb or Ezra Hudson, told the court that the first preservation notice that they sent was on December th. Their initial preservation notice was on December th of, and there is actually a preservation notice attached on this docket with that very information. And it tells them, as of this date, you must not delete any messages. Okay, so according to their own previous filings, they were under no obligation to save any documents from December 20th. Until December th, they were under no obligation. Now they're trying to change it and say no, no, no. It was actually from the November letter where I said I reserved my rights. That's ridiculous. It's ultimately, again, a gaslighting technique where she's trying to tell the court it's their fault, I can't prove my case, and she's telling the public, Wayfair destroyed the evidence, and that's why I can't prove my case. But the real meat of the story here is Blake can't prove their case. Her case. She has, after 9 months of frivolous litigation, hundreds of subpoenas, dozens of depositions, she has uncovered not a single iota of evidence of a smear campaign that was orchestrated to destroy her and retaliate against her. This was the same issue that she told them was occurring in August, days before she claimed it happened. Right? She said. The smear campaign happened in the beginning of August. She was already blaming a smear campaign before they ever even hired Judd Wallace. And now she's saying, well, the reason I can't prove it is because they use Signal, and anyone that uses Signal or iMemos that don't save is intentionally doing that to withhold evidence. A judge ruling on that could affect any user that uses Signal or any user that uses iPhone memos. It's so insane. It's just a way for her to PR and get ahead of the PR and delay and delay and delay. Because when summary judgment motions are filed here in a couple weeks, I'm sure what's going to happen is you're going to see Wayfair say that there is no evidence of a smear campaign. You're going to say and show, they're going to show their documents and the discovery that proves there was no smear campaign. And they're going to point out that she can't prove it. And this is, I think, her just again trying to get ahead of it. So if she knows she can't win. So the only way she can win is now if the judge says they deleted evidence, and that's why, and the jury has to hear that they deleted evidence. And they did this even though there's no proof. Oh, this is so funny. I've never seen attorneys act like this, but it's Blake Lively and Ryan Reynolds. So really the big takeaway today, you guys, is that Blake and Ryan are officially admitting by deflection that they can't win the case, that there is no evidence of a smear campaign, and that their only chance of winning is if a judge will give them this harebrained sanction that tells the jury they deleted the evidence. And that's why. And they can't say that they didn't do this because they did it because I told you. And then while they're doing that, they provided no evidence to the judge that this was done. Oh, you can't make this up? You guys, you can't make this up. So what are your thoughts? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed. Then click the bell so you never miss a video. Thanks so much for watching. Bye, bestie.